All right, next we're going to look at Belden versus Feditova. Mr. Hunter's here, and Ms. Feditova is here. Mr. Hunter, I think I need to offer, in light of the last case, since you're representing one of the parties, if you want to go to a representative docket, I could do that. I'm more inclined to allow cases to stay here if I have a unrepresented party, which I do. So do you have any preference?
I don't, Your Honor. In fact, I think we should be able to handle this matter today. I think my client mostly agrees with the requests Ms. Feditova is making. I haven't had a chance to talk substantially about it with Ms. Feditova, but that's my inclination.
Okay. Why don't I hear then from Ms. Feditova? I understand you've done a number of evaluations and have taken some good steps to turn your life around, but why don't you go ahead and address the court as to what you'd like to see?
Your Honor, hello, good morning. So I do admit I was living inappropriate lifestyle that was damaging to my child. You know, I wasn't there for her. So my behavior ended in incarceration from 2017 to 2019. Okay, and then upon my completion of the sentence, I got deported back to my native country. So with some laws changed in Washington State, I was able to come back. Now, the 3 years I was gone from 2020 to the end of 2022, almost 3 years, sir, I had a communication with my daughter over a video for about 2.5 years. And we developed pretty good communication, me and her, given the fact that I haven't seen her for a while. So now, in November, as you can see in the evidence, I was able to come back, sir, to the United States to reinstate my permanent residency here. And in November, when I came, as soon as I got here, sir, I went full blow on making things happen for myself so I don't repeat the same mistakes. With that said, sir, I do not even live in Cowlitz County. I live in a different place. I live in a good place. I obtained employment, which is I'm very successful there right now, and I'm aiming to keep it that way. I submitted to you drug and alcohol evaluation and it said that I do not require treatment. I did a hair follicle, sir, to show that at least a year back, I was being clean. If I could do more look back on a hair follicle, I would do it, sir, for like all 3 years that I was gone, you know, out of the United States. So with that said, I took the classes for the parenting, you know, that was required by me. I also submitted legal paperwork that shows that I'm legally in the United States in a good standing with immigration. I don't have any DOC supervision, sir. And I would like to ask court that if possible to give me visits with my daughter. But Mr. Belden was asking for a year of supervised visits. And sir, honestly, I feel like it's a little bit too much because me and my daughter, we communicated, sir, and given the evidence that I'm doing well, I know it's not going to happen overnight. And the reason I requested, you know, a little supervised visits is I want, as a professional, to observe how me and my daughter physically building up the relationship, you know. But a year of supervised visits, sir, please. I really don't think it's necessary because I'm doing very well.
All right, thank you. Mr. Hunter?
Yes, thank you, Your Honor. We don't dispute many of the facts that Ms. Feditova has stated. She has completed many of the requirements under the final parenting plan in order to resume normal visitation or something that looks like a normal visitation. Our contention here is that the requirements of the final parenting plan state that there has to be 1 year drug-free evidenced by a 12-panel hair follicle test taken every 3 months. So the order to us looks as though it's saying there must be 3 of these tests, or there must be a test taken every 3 months for a year. We do agree that the final parenting plan...
Mr. Hunter, your sound is starting to garble a bit. I don't know if there's something you could do to fix that, but it's starting to affect our ability to record you.
Oh, understood. Let me see if I can switch from my earpiece. Maybe that can fix it.
Court, hear me a little better now?
Yeah, that's a lot better. And it was unusual because I've never had an issue with your sound before.
It's been acting funny lately. So, Your Honor, our position is that the final parenting plan states that there has to be a 12-panel test every 3 months for 1 year, and we think that that makes sense in this case because Ms. Feditova has been incarcerated. She has been overseas to a war-torn country and returned. She's now in the environment where she was previously, where she had received her drug convictions. And so there's some concerns that being in the same place, in the same area, could present some hurdles for her. So we still think these 12-panel tests are necessary. We don't disagree that she should have visitations. She should be allowed to have visitations with the daughter. We think the 2-hour supervised visits are still appropriate. And we do think that the final parenting plan requires an order allowing her to resume those visitations as well.
Resume what, unsupervised visitations?
To resume supervised visitations.
Okay.
The road to recovery, which is that section 6.3 of the final parenting plan.
Yeah, I have that in front of me here.
Okay. These are the requirements, many of which Ms. Feditova has completed, which is excellent. But these are the requirements to resume to a more normalized visitation, and Father is very much open to that. Once we complete the requirements, and that's our position, Your Honor.
All right, thank you, Mr. Hunter. Any response to that, Ms. Feditova?
Your Honor, I am very open to do a hair follicle test, because I feel like that is a very, very good way of proving what I'm doing, because you cannot fool a hair follicle test. So I am very open to that, sir. But supervised visits for a year, sir, I don't present any danger to a child. And if my I'm willing to do the every 3 months, every 90 days, a 12-panel hair follicle test at my own cost, sir. But when I go to supervised visits and it's once a week for 2 hours, sir, I'm paying $80 for a visit. And then I have to pay $75 for UA. It's every single week. That puts financial strain on me. And if I'm doing a hair follicle, sir, and I'm showing that my hair follicle is clean, and I am having a good progress with my child, which is under supervision of a professional, sir, I mean, I feel like that's excessive, sir, because I showed that I accomplished a lot within a short time. And like I said, as you can see from my hair follicle results, I've been clean. And if I could go any further back, I would even show that I've been clean since the day I got out of prison. And in prison, I went to therapeutic community treatment. Okay, I was on good behavior. That's why I was let out early. So obviously, if I was doing drugs while being incarcerated, then, I mean, that would continue my habit. I mean, I've done it before, where I was reckless and careless, sir. But now I'm doing everything. And the person who is doing drugs, they're not able to keep employment or lead a lifestyle to where I can provide UAs. I went to take a drug and alcohol evaluation. I submitted UA there too. I went to my job. I did submit a UA. So it shows over time that I'm clean. So I would like to see if you can please take in consideration, maybe I can do hair follicle every 90 days. I'm willing to do that at my own cost. But the excessive UA every week, sir, I mean, I'm not doing anything to even have that suspected behavior. And me being back in the environment, sir, there's drugs everywhere. They're in Europe, they're in my home country, they're in America, everywhere. If a person really wants to do them, they're going to do them. So me being back, I live in a different county. I live in a very good environment, sir. And I am...
We just lost your sound.
Okay, so I don't know what the last thing you heard, sir, but I'm asking the court if I can please reduce the supervised visits time length and let's say maybe 6 months and see how this goes. And I'm willing to submit hair follicles if I have to do it before even the first visit, because it's been already 3 months, I think, since my last one. So I'm willing to do that, sir. And I already submitted to the parenting place all the paperwork that showed what I need to do in order to complete the road to restoration. And I would like to see if you please consider a little less time than a year of supervised visits, sir, please.
All right. I want to just make some general comments. I want to commend Ms. Feditova for taking all the steps she's had. And honestly, you've to move back here, go through whatever immigration issues you had to go through, and then do the treatment. That those are a lot of hoops. And so I want to commend you on that. I also want to commend Mr. Belden. Ms. Feditova had been out of your daughter's life when she was, I guess, in Europe. You allowed her to have video visits. Today you're coming here saying that you'll agree to supervise visits. And I think that's commendable that you're willing to accept that at this point. So we certainly have to start with supervised visits. And I think the one difference there may be between what was going on in 2013 and today is that there has been some video visit contact with the daughter. And so we have a relationship going. We have a relationship going with somebody who's now who doesn't have a drug problem going on, and the daughter, has some contact. So because of that, we may be able to decrease the amount of time of the supervised visits, but I don't know if that is going to happen. What I'm going to do is check in every 3 months. I want to see the reports from the supervisor on the supervised visits, and I want to see how things are going. Okay.
Yeah.
I'm going to consider the December 2022 hair follicle test as your first hair follicle test. All right. So I want you now to get a hair follicle test in the next, ideally by tomorrow. If you can't get in, I'd like it by Monday or Tuesday next week. And that will be your second hair follicle test along, this road to 4. Okay. The parenting plan calls for supervised visits. It's 1 2-hour visit a week at Parents Place or Progress Center. I'm not sure they're both in operation, but I'm going to leave it to Ms. Feditova to make those arrangements to set up those supervised visits, and then let Mr. Belden know, or let his attorney know. Which would you rather have, Mr. Hunter? Do you want her to contact you on that?
I think she can contact Mr. Belden directly. The parties have a good relationship.
So let him know if you're aware that certain times he's in the middle of work and it would be difficult to deliver your daughter. Try to work around that.
Yes.
But Mr. Belden, when she selects a time, then it's going to be up to you to bring your daughter over and then also pick her up after the visit.
Your Honor, this is Beth Fellows, owner of Reconnecting Families Visitation.
Yes.
And I have had contact with the mother. So she's basically set up to start the visits. She's actually paid for the first visit. I have also talked to the father as well. And he has the intake packet. I just don't have it back from him. So just letting you know, Your Honor, that things have been started, and hopefully within the next week or so, we could get visits on the schedule.
Okay, that's very good. All right. So when you do the next hair follicle test, you need to file it with the court under seal and give a copy to Mr. Hunter so you can just send it to him. Okay.
Yes, sir. Will do.
I'm going to set a review hearing for July 20th at 9 o'clock.
Okay.
I want you to do another hair follicle test right before that hearing. So
yes, sir. Will do.
That will be your third. And Ms. Fellows will give you her observation notes from those supervised visits. I would like those filed with the court prior to that visit.
July 20th. Yes, sir.
Prior to that hearing on July 20th.
Okay.
So then I'll be able to review those, make sure the hair follicle is clean, and just see how everything else is going. I may not allow unsupervised visits at that time, but I want to make sure we're on the right track, okay? And then
Yes,
we'll
sir.
go out 3 more months if we need to, and then we'll see where we go then, okay?
Thank you, sir. Yes, thank you.
All right, Mr. Hunter, any questions?
No, Your Honor. Would you like me to draft this order?
I think that would be good. If you would do that, I would appreciate it.
Okay, I will get that drafted and circulated and filed with the court.
Okay, good. All right, thank you both, and good luck to Townsend.
Yes, please.
Thank you.
Thank
Your
you.
Honor.
right.
Thank you.
Mr. Morin.
Morning.
So this is a request to increase child support, and brought by Ms. Townsend. So I'll let you address the court first, and then I'll go to Mr. Morin.
Okay. Thank you, Your Honor.
You bet.
Paul and I have 2 children together, 7 and 9. And the original order for child support was given by the court back on October 27th of 2020. And at that point in time, the, I guess, reduced rate, if you will, of child support for, $100 a month was given to Mr. Morin. And, for the majority of 2021 and 2022, Mr. Morin was paying that. And then I think December 2022, he stopped paying child support and hasn't paid since then. I've sent him requests to pay that money through Venmo, which is how we've been paying it, and he declines those requests. When I ask for child support, he asks me what the boys need, indicating that he's only going to pay for things that they need. When I, talk about the fact that child support goes to things like, food, general clothing, helping keep a roof over their head, all of the, general expenses that go into raising children. His response is that he pays those things too, and he hasn't given me any money. So I submitted a request to the court with Mr. Morin's new income for an increase in child support. And I'm requesting also that, given the language that Mr. Morin uses towards me, the derogatory language that he uses towards me in text messages, that child support goes through support enforcement, so I don't have to be subjected to that.
All right, thank you. Ms. Morin?
Thank you, Your Honor. That is correct. I have not paid. I've paid through December 2022. I guess there's some confusion on our out-of-pocket expenses and how those are divided and what should be covered versus included in the child support amount. Clothing is one of those out-of-pocket expenses, as well as extracurricular activities. When I submit receipts to Lauren for reimbursement on clothing, or most recently BAT, which was $200 for Little League, I don't receive any compensation for those as well. So me being on a tighter income than Lauren is, I do only have so much money to spend on the boys, including extracurricular activities, out-of-pocket expenses for clothes. I've included some receipts to show what I've been spending out of pocket. It's not all inclusive, but it is a good example. As far as the $100, if you look at our initial filing, that was what was mediated and agreed to upon. There are some deviations related to tax benefits. Lauren has been claiming both of the boys for the previous year since the divorce. I also pay 60% out of pocket for medical expenses. So I am requesting that I am in agreement. I would be okay with them withdrawing it from my check. That would clear up any issues with that. I do understand there's an increase in costs and expenses as well. I am requesting a 30% increase over what's been paid previously of $100. I'd also request
You're
adjustment
asking for $130.
Correct.
Okay.
requesting that I be able to claim at least Benjamin Morin on taxes moving forward, and requesting a 50-50% split on out-of-pocket medical expenses. I'd also like some clarification on what is to be split for additional expenses regarding clothing, extracurricular activities, and expenses related to those.
Let me just ask you, she has you listed as a gross income per month of $69.71. Is that in the ballpark?
I submitted my worksheet with that based on the directions and instructions for that. My gross monthly income is $6,477.
And what amount do you pay for the health insurance? Do you know?
Your Honor, if I may, he doesn't pay anything for health insurance. I get health insurance for our children for free through my employer. There has been one incident over the past 2.5 years where Paul had to pay 60% of this $1,000 anesthesia fee. So Paul paid, I think, $600 and I paid $400.
Was that because it was an uninsured
Yes.
cost?
Yep. But when it comes to like buying prescriptions or co-pays, those are things that I'm paying because I'm the one that's taking the boys to their medical appointments. But to be fair, I haven't asked Paul for those things either.
Correct. Yeah, the agreement, Lauren receives her medical through work, through Kaiser, so they are under her medical with zero out of pocket, other than the uninsured expenses.
Okay. All right, Ms. Townsend, you can respond if you'd like.
Excuse me. So, I mean, just to the piece about the medical care that, again, over the past 2.5 years, there's only been one incident where Paul has been asked to pay anything for out-of-pocket uninsured medical. So that's not really a standing expense or an existing expense with the rare occasion of something coming up. The other piece is that, in the previous order that was issued, Your Honor, the language is specific that school supplies and school wardrobes are both to be split at 50% between Paul and I. And so how that has worked for us over the past 2.5 years is that in the summertime, when I go school clothes shopping for the boys, that I ask him to pay 50% of that. And he has done that on both occasions, although most recently there was a lot of negative feedback around it. And then in terms of extracurricular activities, Paul and I share 2 very active boys. And so there's pretty much a sport or an activity that they want to do every single season. Our 9-year-old wants to do wrestling and basketball and football and flag football and baseball. And so those things, yeah, they are expensive. And we have historically split those things 50%. But as of recently, when I've asked Paul, to split like the cost of flag football with me, for example, which is $160 for both kids, his response back to me is, well, I didn't agree to that. And so he hasn't paid his half of that because he was not in agreement.
Okay.
And the tax piece, Your Honor, is that with Paul paying such an insignificant amount in child support, it doesn't seem, I guess, fair, for lack of a better word, that he would get the tax benefit when all he's paying is $100 a month.
What if I ordered that child support go up? Would it make sense that he get at least one exemption?
I think his ask that it go up to $130 total. I would not be agreeable to the tax credit going to him if it goes up to $130. That's really not a significant increase.
Okay.
But I mean, if there's a significant increase, then sure. I mean, if that wants to come with a tax credit. But at the present, $100, Your Honor, it really isn't anything when you're talking about child support for 2 children when we have 2 working professionals here.
Well, your calculations have them at $992 a month, right?
Well, that's the what do you call it? The equation that they have with this worksheet.
Right. What are you asking for?
Honestly, that seems like an excessive amount. I don't need that much money from Paul. That seems like an excessive amount. I would, leave it to the court. But I don't need that. And I mean, I know that would leave Paul in a bad spot, and I don't want that for him either. I just want some more equality in how we are, the financial, contribution to raising our children.
Okay. I think it's clear to me that child support has to go up. The gross income is, for Mr. Morin is, I think he said around $6,500 a month. He's got 2 sons, and certainly $100 is not an adequate amount for that. So I'm going to kind of structure this a little bit. I'm going to raise the child support amount to $600 a month. Out of that, the mother is to pay for any clothing that she buys. So there won't be any division on the clothing.
Does that include clothing for my house? Are they to pack a bag now with clothing, or am I still purchasing clothing?
And if you want to purchase clothing for them too, you can, but you're not going to get reimbursement from Miss Townsend.
So Miss Townsend's providing their clothing.
So I'm taking clothing out of the equation here.
Okay.
By giving her more money than if she wants to buy clothing for whatever reason, I'm taking that out of the equation. $600. I mean, the standard calculation for them is $992, or close to that. It's in the 900 range. So we're coming in below that. Because of that, I'm going to retain your 50% sharing of uninsured medical. And so you have that experience once already. With Kaiser, there's not going to be that many uninsured expenses.
So, Your Honor, just to clarify, currently it's written that Paul pays 60% of uninsured and I pay 40%.
Okay, I'm going to make it 50-50, and the reason is you make more than him.
Sure.
And so I think it's appropriate to do a 50-50.
Okay.
And that will also be 50-50 on extracurricular activities. And that's, if Mr. Morin buys something in the sports area for the child, such as the baseball bat, then that cost gets shared 50-50.
Now, does this agreed upon, or can Miss Townsend just sign them up? Endless amount of activities, multiple activities at a time, like that's going on currently?
Let's say, some kids are high octane kids and they do a lot and they need to do a lot. And Miss Townsend, it sounds like, is the one that's kind of closest to that. I think if she signs them up for an activity and they clearly are participating in it, then it's something that needs to be shared.
It just seems excessive in my mind. They're both on a little league team and they both have flag football currently. So I'm a single dad with most of my support in Massachusetts. I can't be in multiple places at the same time. And it also takes away from the quality time that I want to spend with them during my time as well. So I ask that we can agree to the extracurricular activities as well.
Ms. Townsend.
I would respectfully disagree with that, because Paul has told me before that he only thinks the kids should do one sport a year. And we, again, our 9-year-old wants to literally do everything. He wants to do baseball and flag football. He wants to do wrestling. He wants to do basketball. If there's another sport, he'd probably want to do it too. He just loves that. And our 7-year-old, he loves wrestling. He's playing baseball right now. He wanted to play and wants to play flag football. So these are all things that the kids want to do.
Benjamin did not want to play Little League.
No, they can't, because
okay, we're not going to discuss this here. Let me
You also pressure them into.
I'm
Ben did
gonna
not
let
want to
this-
play Little League.
I'm going to let Ms. Townsend make that determination, but here's what I've done in the past, because this is a conflict that comes up on occasion, where one parent doesn't believe the children should be involved in certain extracurricular activities, the other one does. And so how do we figure that out? What I've done in the past is I've converted whatever Mr. Morin pays into a set sum every year, and then it just goes to the other parent, and they can use it any way they want. I don't know if we're there yet, but I'm going to give Mr. Morin the opportunity to come back to court if he feels these expenses are way out of line. I don't know if they are yet, but if you do, then go ahead and make a motion and ask that the court set a fixed amount that you pay, rather than feeling that every month you're getting another bill for something that you don't agree with. Okay. So I'm going to leave extracurricular at 50%. And I'm going to start the 600 in May of 2023. It seems to me that the current order is $100 a month, and that hasn't been paid from January to, well, April. So I think there needs to be a $400 back child support amount put in the order. As to the tax exemption, again, I'm awarding child support that's at least $300 less than the standard amount. And so I'm going to leave the exemptions with Ms. Townsend. Should at some time the child support become in line because of another motion, if it's the same as the standard amount, then I'll certainly revisit the tax exemption at that time. Right now, I think Mr. Morin is getting quite a benefit. Okay. All right. Does that answer all the questions, Ms. Townsend?
I guess, Your Honor, I just wanted to clarify about how the child support would be paid. My request was to have it paid through support enforcement, because Mr. Morin uses not nice language towards me when we communicate about money via text. So if you could just make a motion on that.
When the order of child support is made, and I've got your order to adjust, which I'll sign, but I don't have an order of child support. Can you put that together and submit it to me?
Yeah, will you just tell me exactly what that is, though, that I need to submit?
If you go to Washington State Court Forms, and under, I think it'll have a section on child support, and there'll be an order of child support.
Okay.
I'll probably need to make a motion for a long distance parenting plan as well. I'm not going to be able to survive alone on this, so I'll need to move back home, my support and family.
If you need to have a long distance parenting plan, then you can come back to court and we can address that.
Okay.
All right. Yeah, if you could submit that order, then when I get it, I'll make sure it conforms with what I decided, and I'll sign it. And when you get the order back signed, you should contact the Division of Child Support. There's a division in Cowlitz County that you can call, and they will lead you through the process of them stepping in and collecting the child support. That isn't something that I do from here. Okay. All right. Mr. Morin, any questions?
I'm not going to be able to survive with this, so thank you.
Okay. To Cody Wade. All right, Lacey. Thank you both. And I have both here. And Ms. Fellows, you're on that case.
Yes.
So we're here to check in on visitation. There's been some concerns raised about Ms. Harlan being around somebody who uses drugs. And so I want to give everybody a chance to discuss that. And I have some, I've also expressed a concern at the last hearing that Mr. Wade was not getting any weekend time with the child, and I wanted to try to rectify that if I could. I think I want to hear from Ms. Fellows first, and then Mr. Wade, and then I'll end with Ms. Harlan.
Thank you, Your Honor. Yes, there's been a lot of things that have happened since we were in court last, and I am exceptionally happy to report that things have gotten better, and that I am actually making some very significant recommendations. Both parents know about it. They've kind of wrapped their mind around it. So what I'm going to recommend is going to a week on, week off rotating schedule. That way it will give each parent weekend time and during the week time. I'm also recommending that there be 2 video visits. Your Honor has in a prior case been very specific about those video visits, so there's no issues. So I'm recommending or suggesting that they be Tuesday and Thursday at 7 p.m. That there be no romantic significant others introduced to Cashton unless they've been in a committed relationship for 6 months. That the mother not allow James Doherty Sr. to be around Cashton at any time. That is a prior significant other of the mother, and that is a person who is actively using drugs right now. And so that's based on that recommendation. That the mother not leave Cashton alone with her older son, JJ, at this point in time. There is 619 pages of CPS records that I need to review. There's issues or has been issues regarding her son, JJ, but I'm not sure exactly what all of those are. So that's why I'm just making that recommendation for this point in time. And then my recommendation is also that the exchanges be on Fridays at the daycare. So those are significant changes that both parents have talked about and agreed on to lift or dismiss their respective restraining orders against the other. I believe that they have court hearings, I think next week, but mom actually talked to me or emailed me about it. I talked with both of them actually on the phone as well, and they both agree they want to be able to communicate with each other instead of having to use a third party. I have suggested using a communication app like Our Family Wizard or Talking Parents or something like that. Both of them seem like they would be agreeable to that as well. But what I would definitely like to report to the court is that both parents have with me talked about wanting to work together with the other parent. They want to be able to learn how to co-parent. That's a significant change with these parents, and I'm thrilled. I really want to see how well this works out. So I would like to have this recommendation put into place for like maybe about 60 days, and then be able to come back to court and hopefully be able to finalize.
All right, thank you. Mr. Wade, any comment?
No, yeah, actually, I don't have any objections to any of it, but the 2 video visits a week, I was kind of, I'm not objecting to more than that. Like if I wanted to call my son while he's with her, if she wanted to call me or her son or our son while he's with me, or video visit, I wouldn't have a problem with that. Just the 2 is kind of, I feel like I would like to tell him good night and stuff, and if that would be okay. But other than that, I'm good with everything.
You want to be able to contact him more than twice a week, is that what you're
Yeah,
saying?
I'm not going to be blowing up her phone or anything like that, but maybe, I'm sure, I don't know if she would be agreeing to it, but if not, then I'm okay with it. But
All right, thank you. Ms. Harlan?
I'm in agreement with all of that, and I agree with him as well. I mean, because a week apart from our son, we're both very close with him and always have been. And it would definitely be nice to be able to talk to him and say goodnight and things like that. I don't want to fight with him. We're trying to get past this, obviously, and it makes me really happy. Do we have to use the app like that, or could we possibly use like Messenger or just be able to call each other? I mean, because it's just a lot having the courts involved with everything, and just want to get back to more of like a normal type situation.
So using the app, we find is important because it will keep a permanent record of that communication. And I think at least for the next 60 days, I would like that. And I see you're on, I'm going to be the judicial officer on Monday, where you're asking for a termination of the protection order. And that will probably be a condition of terminating it, is that you use the Our Family Wizard app, if that's the one that you choose to use. Now, if things are going great at the end of 60 days and we enter into a permanent arrangement, then we might be able to step back from that. But I think the next 60 days, I would recommend that. Mr. Wade.
Yeah, I was kind of against the app also, just because it costs $100, and I'm trying to get the courts out of it. I'm not trying to fight with her either. I'm just trying to get my life normal. I have so many appointments and so many everything, and then having to remember to do the app thing, and I don't want to get in trouble for trying to call him with, I don't know. I would rather not be the app too, if possible, and see how that goes. And if it doesn't go good, then we can go to that. I tried to talk to Beth about that also, but the restraining order thing is kind of, I don't want to have to communicate through that if possible. I tried to talk to Beth and let her know that too, but yeah.
Ms. Fellows, what's your thought after hearing this conversation?
I think that there's maybe some misconception about what this communication app is about. And I've tried to explain it to both of them. It's just that it's one platform to be able to communicate instead of doing texting and email and messaging. Those are all different platforms. Like Your Honor said, it's one place to have communication. And that's all that's about. It's not that they can't phone call each other, but it's also a way to document things, about doctor's appointments or, things like that. It's not where the courts are involved or anything. Our Family Wizard, I did let them know that there is a way for them to give me access for while I'm in the case. That way I can kind of monitor what they're doing. But other than that, it's a one place for the communication. So I do think that would be a really good thing to do. And between these two parents, there's been a lot of back and forth. If the court, I'm sure, remembers the court hearings where things have just been strewn about and accusations made and things like that. And so really trying to keep this forward motion, keep them on an even keel as we move forward with like doing this week on, week off. Makes sense. And I think once they see the app and see the benefits to that, I think then they'll be more understanding about it. But at least for these next 60 days, I do think it's important.
Is there a time where is it Cashton is out of daycare?
Yeah.
What time I'm just for the Friday transfer, what time would that be?
He's only allowed to be there for 4 or 5 hours because it's just a different daycare situation. We're trying to get that changed, and so I'm trying to get the protection order off too, so we can communicate about that also. But it's usually 2:30 or 3 o'clock.
Okay.
And if I could say something else,
Sure.
I don't have a problem with the parenting app. It's just I heard you say something about the restraining order. I want it to be able to, if she needs to have my mother or me watch him while she has to go do something, or if I need to have her help me with something, later down the road, I want that to be able to be okay without getting in trouble and having to go to jail or something like that. I don't mind the app. I just, if there's needs to be other kind of communication or contact, I don't want that to be an issue.
Okay, I understand that.
because I know that I have a hard time doing it by myself, and I'm sure she does too. And I don't know, I just feel like it would be easier if we could, if she needed help, she could drop him off at my mother's house, or when I get a place or whatever, you know. I just don't want it to be a thing to where we're going to get in trouble for swapping kids somewhere else besides daycare if need be, or helping each other out if need be. I don't know.
I don't see that as an issue. All I was saying about the protection order was a condition of letting it go. I wanted, I guess, most of the communication to go through a parenting app, so that there'd be a record of it that could be looked at if we needed to.
Okay.
So first of all, as I do whenever I can, I want to commend everyone here for working together. Everybody had to get through a number of issues, and I'm really glad we worked up to this particular recommendation. And it's always better for your children if you're getting along. And Ms. Fellows, I appreciate your work in this and working with both parties to get to this agreement. So it will be the order of the court that there be a week on, week off, beginning with Friday at or before 3 p.m. from the daycare until the next Friday at or before 3 p.m. The parent receiving the child will be the one picking up at the daycare for the next week. During that week, the parent who does not have the child will have at least 2 video visits on Tuesday and Thursday at 7 p.m. But it sounds like both parents are agreeable to any other additional video visits or telephone calls if they would like. So I'm not going to get in the way of that.
Thank you.
You're to not introduce any other significant others to the child until the relationship's gone on for 6 months. James Doherty Sr. is not to be around the child at any time.
I'm agreed on that as well.
Okay. The child is not to be left alone with your older son, JJ. And I will take all of this into account on Monday when you're asking me to lift the restraining order. And it's likely that I will.
Thank you.
All right.
I did have one question. So when would the week on, week off start? Because today I pick up Cashton and have him till Monday usually. So
can we have today be the beginning of Ms. Harlan's week, and then next Friday, Mr. Wade, you would pick up Cashton?
Yes, I agree to that. So he'll start today, then go with her, and then come back Friday.
Yeah. So you'll get Thursday, Friday this week, and then starting the next week, it will be Mr. Wade's week.
Okay.
Okay.
So, I have a calendar floating here somewhere. I'll just to be clear about. In terms of Fridays, the 21st through the 28th will be Ms. Harlan's week. The 28th through May 5th will be Mr. Wade's week, and then it will alternate.
Okay.
Okay.
What about the review in 60 days?
Oh, that's true.
Okay.
So it's the 20th. We want to go to June. That would be June 22nd.
Okay.
At 9 a.m. If there's a need, either of you can note a motion before that time. Hopefully that won't come up, but I just want you to be aware you can do that. Also, Ms. Fellows could put this on the docket should she feel it necessary. But hopefully I don't see you till then, and we have a good discussion on the 22nd. Okay.
Thank you so much.
This is a wonderful way to end this docket. So thank you and good luck to both.
Thank you very much.
Thank you.
Take care.